There is a regulatory office called the Office of Information and Regulatory Affairs. It appears in no law you have read, and since February 17, 1981, it has rewritten, delayed, and killed thousands of federal regulations without entering a single explanation into the public record. It has operated from inside the White House for more than 4 decades. You were never told it existed. What it does in quiet, and what it buries stays buried. OIRA, pronounced OIRA, sits inside the Office of Management and Budget, inside the Executive Office of the President. It employs roughly 50 career analysts. Its administrator is confirmed by the Senate, and it reviews every significant federal regulation before it is published into law. Every one: clean air standards, drug approval timelines, food labeling rules, workplace safety requirements. If a rule is projected to cost more than $100 million a year, or if it meets OIRA's own definition of significant regulatory interest, a phrase OIRA defines for itself, that rule does not reach the Federal Register until OIRA clears it. This is how American law actually works. Most Americans have never heard this office named. Congress did not grant this authority directly. The Paperwork Reduction Act of 1980, codified at 44 United States Code Section 3501, created the office to reduce administrative paperwork burdens. That is what the vote was for: paperwork. The power to review, halt, and rewrite regulations issued by the EPA, the FDA, the Department of Labor. That power came from Executive Order 12,291, signed by President Reagan on February 17, 1981. No floor debate, no committee vote, no public comment period, one signature. An office built to count forms became the gatekeeper for the entire federal regulatory apparatus. Clinton revised the framework with Executive Order 12,866 in 1993. Obama reinforced it with Executive Order 13,563 in 2011. Every administration since, both parties, every political season has kept it, used it, and extended its reach. The question of who controls OIRA is the part no one resolves cleanly. The administrator is Senate confirmed, which creates the appearance of accountability. But the meetings, where industry representatives, corporate lawyers, and trade association lobbyists walk in to discuss a pending rule before the public ever sees it, those meetings appear on a public disclosure log by name and date only. Not by topic, not by substance, not by what changed in the draft afterward. You can verify that a meeting occurred. You cannot determine what was requested, what was agreed to, or what the analyst wrote in the margin of the rule the following morning. Remember, no one voted for this process. When OIRA decides a regulation does not meet its cost-benefit standards, it issues a return letter. The letter sends the rule back to the originating agency. It may describe the objection in general terms. It does not specify what a compliant revision looks like. It does not open a new public comment period. The rule is simply returned, and it may sit, revised once, revised again, quietly abandoned for months, for years, or indefinitely. Federal regulators have a name for this outcome. They call it the desk drawer. Between 2001 and 2008, the Government Accountability Office reviewed OIRA's records and found dozens of rules returned or withdrawn during review with no written explanation preserved in any accessible file. Agencies sometimes could not reconstruct what OIRA had specifically objected to, because the objections had been communicated informally, in meetings, in phone calls, in the hallway conversations between an analyst and an agency rule writer that leave no transcript, no memo, no email chain subject to a public records request. The rule had been changed. The reason it was changed does not exist in writing anywhere. And here is the part that should actually worry you. Every bit of this is completely legal. Because the review authority flows from an executive order and not a statute, it sits below the threshold of judicial challenge. Courts have consistently declined to examine the substance of OIRA decisions, holding that internal executive deliberation is insulated from review. There is no statute to repeal because there was no statute to pass. A new president could rewrite the framework, but no president has, across 11 administrations in 4 decades. The office survives every change of party, every campaign promise about regulatory rollback. The desk drawer that Reagan built is still in the same building. It has different analysts now. The rules that go in still do not always come out. What this means is that the regulatory system has a hidden layer, operating between the agency that writes the rule and the public that will live under it. The EPA is accountable, in theory, to congressional oversight and to federal courts. The office that reviews the EPA's work before any of that accountability can engage is accountable only to the president. Through an executive order, no administration has reversed. Every major regulatory action of the past 4 decades, clean air thresholds, pharmaceutical approval timelines, financial disclosure requirements, workplace exposure limits, passed through this office before it reached you. Any of it may have been revised in a meeting that left no record, for reasons that will never appear in any public document. The question no one has answered publicly is this: if a single executive order in 1981 could quietly install a second legislature, 50 people, no recorded deliberations, no judicial oversight, operating inside the White House without a vote, what else was built the same way in the years since that you simply have not been told about yet?